Coming to you live from Radio Cayman Studio.
For the record.
For the record. Hear from your government officials, independents, and the opposition on issues that matter to you. The record. Engage in an open dialogue between residents and lawmakers.
For the record.
The record. Informative, impartial, insightful.
This is your talk show.
1-800-534-8255. Your calls, your input. This is For the Record. And now, your host, Orit Connor.
Between being well regulated and being able to enforce and to ensure that there is compliance with the laws of the jurisdiction?
Well, of course, I think we have a problem with, we have enough regulations. We are regulated to death here. Uh-huh. It's the enforcement that is lacking, and that brings me to the comedy, the rule of comedy. That I would say that comedy has its role as entertainment now and then, but now comedy, but when comedy begins to become reality, it's that time to turn up the lights, bring down the stage, the curtains on this stage, on the comics, and bring the reality actors back. That's what's been happening over the last week or so. It seems to me that there has been an entertainment especially in the Legislative Assembly. And what brings to mind this morning is what is the remit of the PAC committee in the Legislative Assembly? That is a question that we ought to be discussing for the rest of the week, I would say, when we have time. Mm-hmm. And the other matter that I see that's highlighted in over the weekend was the power of the Speaker to hold MLAs in contempt of their actions outside the House. Mm-hmm.
And we will be looking into those things.
So does he have that kind of power? And those are the things that I'm interested in. The remit of the PAC committee. How far can they go? What can they do? And the power of the Speaker to hold MLAs in contempt, and whether or not there are any powers in the laws, in the immunity and privileges law, or the standing orders, or the Constitution to allow that to happen.
Okay, we have one caller. Let's go to the phone lines. Caller, good morning. Welcome to For the Record.
Good morning again.
Good morning, sir.
Panel, because the whole half the world knows who you are. It's interesting you're talking about is enforcement, because that's the same thing I'm following up on again about enforcement. It's a labor problem in Cayman. I recap a bit, the problem is that these people are not advertising where they're located or not getting a phone call. And I don't see why, because it's so much easier if you just advertise, say, okay, we need auditors, front desk, and bedroom people at the, say, Western Hotel. Next week, Thursday, we have an interview. Anybody coming, just come in, we get interview for you. To put a phone number fax, you have to go downtown, mail a letter, wait for them to call you back, and you don't know when you're going to go down. It's much easier for all around. But just set a date, we're taking interviews for this job, right? And again, what the enforcement part? Who is responsible for enforcement? Is the police? Is the enforcement part of the immigration? And then is there any fine? If I don't put on my seatbelt, they're going to charge me. If I don't smoke a little sniff of ganja, they're going to enforce me and charge me. But something very important like this in the islands, in employment, why is it not enforced? And why is there no charge or fine to the people responsible if they do not enforce it? Yeah? Well, that's enough. I can discuss that a little bit, gentlemen. I want to find some of those answers. Thank you very much.
Thank you very much, caller. For that as well. Thank you. Getting back to the Paradise Papers, and I'm wondering if and when, because sooner or later it's going to come. These hackers have the ability for getting into things when some major law firm in the Cayman Islands may be infiltrated either electronically or otherwise. And what we're going to call those papers then? Are we going to call them the
Caymanian papers?
The South Church Street papers, the 7 Mile Beach papers, or, what are we going to call them then? But when we look at the Canadian case, and you spoke of Justin Trudeau, the heir to the Seagram's fortune, which they lost billions in the sale of this the Seagram's company to a company called Vivendi. They lost a couple of $1 billion on that sale. But Bronfman, and when you look at all of the political intrigue, Mr. Gilbert McLean continues to hammer home here in the Cayman Islands that we need to have proper campaign financing laws in the Cayman Islands. It is when you see the intrigue that takes place in the financial industry here in the Cayman Islands, we need to know who is wagging the tail of the dog here in politics. We need to know who is wagging the tail, because there is big money. There is no accountability for it other than what you're allowed to spend during the course of an election. But we have no control over the war chests of these political entities. And when I say political entities, I'm not just talking about political parties. I'm talking about anything that they may have established, including just individuals who may get money from people. We need to know the money trail. We need to know where it is coming from, because other than what you get to run your elections, that amount that you're allowed to spend, there is no accountability otherwise. And we see where there is an opening, there is the possibility of it happening in the Cayman Islands, and I have no doubt that it is happening in the Cayman Islands. We need to reform that.
Well, that's because there is no rules and regulations under the relevant law, the elections law, or any other law that says that you have to disclose finance contributions. And many other places, and especially in Canada, you have to have the political parties have to have an auditor who keeps the books, and every contribution that they make over a certain amount, I think it's over $50 or $25, has to be recorded and has to be reported. And it has to be reported who it comes from. Because otherwise, you will have handlers handling politicians and pulling the strings behind the scenes. They pulling they become the puppeteers, and you'll never know who is in control of the legislative assembly or the house or the parliament outside of the parliament. That happens all the time, and I mean we now living in a modern world with a modern constitution, so to speak, and that should be one of the things that we should be doing. Political parties ought to and should disclose whoever they are getting donations and contributions from, and that should be made public, and that should be something that anyone can go and look at, because it should be completely audited.
Okay, we have to go to a commercial break now. Folks, please stay tuned. For the record, we'll be back shortly. Good morning and welcome back to For the Record. In the studio with me this morning, Mr. Risa Pitka and Dr. Steve MacPhail. After the 8 o'clock news, we expect to have some guests here with us. Director of the Department of Children and Family Services, and one or two other persons, or we're going to be talking about our youth and abuse, child abuse in the Cayman Islands and internationally as well, the whole issue. One of our listeners wants to know, asked us to explain how this shows that the Cayman Islands Monetary Authority isn't doing their job. They don't see that. And what they mean is that when they say this, this whole scandal. Well, I'm not saying that the Cayman Islands Monetary Authority isn't doing their job. The question is, are they doing it as thoroughly as needs to be done? When I read the story on the part about the compliance officer and his findings and the audit of the companies, other than those companies having their own internal audit of the various files, the various companies that they have on their books, does the monetary authority do the same in terms of auditing these particular companies? And if that is the case, have they been able to find areas where there is insufficient information in relation to their clients, knowing who their clients are? There was one story there about a connection with Saddam Hussein, and there was another one about an arms dealer, and the name of the person. I'm also told that these companies, these law firms, they have specific computer programs that they're able to do searches on a name to find out what connections that person has. Usually, if a person has a political connection, it will raise a red flag. So my question in my observation in relation to the Cayman Islands Monetary Authority, do they actually find instances of these? And if they do find them, then what is done about it? They cited one case, not in the Cayman Islands, but in Bermuda, where it was discovered that was done, and the monetary authority there decided that they would keep it under the rugs, not bring it to the public's attention in terms of what has happened. They have now changed their legislation in there where there is public reporting when these things are found. But my point for the Cayman Islands Monetary Authority is, do they have sufficient staff? Do they have sufficient resources to do these?
There are two questions that I'm hearing here.
Mm-hmm.
Certainly when I worked with the larger law firm on island, they were vigilant.
Mm-hmm.
You had to, even the lawyers and partners had to do compliance exams, and they were thorough. You had to do it every year. And they were very vigilant with respect to doing the KYC, really, because they know that their whole business hinges on having the level of transparency that is required. But also remember that under our legislation, CIMA don't have no jurisdiction over law firms and regulating them. So that's one thing that you need to bear in mind.
Okay.
But I know from my own personal experience that the firm that I used to work with, they were really, really tough on compliance issues. And I know in recent times, CIMA has now even been questioned about whether or not they're going to regulate with a light touch or a heavy touch. And I know that with respect to the offshore risk insurance business, because they do go into these firms and review the files.
So these funds that are established, the various trusts and stuff like that, they're not governed by CIMA?
No, CIMA don't know. Let me stick a pin here. When I was working in the major firms,
mm-hmm.
I know as a fact that CIMA didn't used to go in there, but I also know, based on my own personal experience, that they were pretty vigilant with the way in which they investigated the clients. And it's one of those things that could get you fired if you didn't know your client, you hadn't done it well. And they had a department that was created primarily to do this sort of thing. Mm-hmm. So maybe someone can call in just to confirm that, because as far as I'm aware, that's not a part of CIMA's
mm-hmm.
remit. But I know CIMA does a lot of good work with respect to the risk insurance management sector, and I know that from on a personal level. So some of the times, the industry is now asking whether or not SEMA is regulating with a heavy hand or trying to find that balance where you regulate with a light touch. SEMA may be accused of many things, and I know they have been in times with, people used to say that the level of competence wasn't there, but I know with time that is not necessarily the case.
Well, I saw this interview, and I think you or someone else may have sent me
I
the
did.
one with Bob Richards.
Yeah.
And it would do well for authorities in the Cayman Islands, especially those in the private sector, when representatives from the International Consortium of International Journalists,
ICIJ,
when they call and they ask questions, not to just give this standard statement that we are a well-regulated jurisdiction, because what they don't know at this point in time is they don't know what they have. And what next is going to be released and how it may tarnish the reputation of any jurisdiction, including the reputation, the jurisdictional reputation of the Cayman Islands as well. We have about 1 minute before we go to our 8 o'clock news. Dr. McFeel, anything you want to say before we go there?
No, I don't want any. I don't have anything to say about that because they have taken away the powerful money away from the local people. You have no access to that. I have no access to that. I know Ms. Pitcairn has no access to that. So I am not interested in them if they get into trouble. That's their problem. That's the reason why I say the couple of weeks ago, and I think that you differed from me when I said that they should be paying for the expense of going out and explaining it about the jurisdiction instead of the government. The government should not be the one defending the Cayman Islands. They should be the ones defending the Cayman Islands, and they should be doing it from their own money, from the millions that they're raking in every day.
The other issue and concern that I have, which I know Roy and Gilbert used to tell me ages ago when they were visiting MPs in the UK, was about whether or not we should really be highlighting developing a different industry, whether it's the service industry. But and that I say that as an aside, but it is what it is, and perhaps these views I'll keep to myself. But we're now faced with this situation, so we have to find the best way to address it.
Okay. Folks, please stay tuned. For the record, we'll be back immediately after the 8 o'clock news.
Thank you, Mr. Conner, and studio time by...
Good morning and welcome back to For the Record. I made an error earlier. Representatives from Children and Family Services will be coming on later on, I think at 9 o'clock as opposed to 8 like I thought. So we will continue with our conversation with Dr. Steve McFeel and Ms. Theresa Pitcairn as well. I have been getting a few messages in relation to the Cayman Islands Monetary Authority, and one message basically says that the Cayman Islands, just the same thing as you said, Mr. Theresa. Actually, the person said they were typing while you were saying it. The Cayman Islands Monetary Authority has no regulatory power over law or accounting firms. They are not licensed under them. If the firms have a company management firm under them, then yes, they regulate that area. And it says that is why we have been fighting to have regulatory oversight of law firms here in the Cayman Islands as well. One caller, let's go to the phone lines. Caller, good morning. Welcome to For the Record.
Morning, OC. Good morning to Dr. McFeel and good morning to Mrs. Pitcairn. This is Johan
morning,
Moxham.
sir.
Morning.
Morning.
I just want to call and lend to the conversation, but offer somewhat of a defense for the Cayman Islands Monetary Authority, who I deal with quite extensively in my role day to day, but also the management team. I just find it really peculiar that sometimes you have industry crying for blood and for consequences, but when SEMA or its precursor, before it was called SEMA, had less sort of international regulatory pressures put on it, and it was headed by a non-Caymanian, at multiple points, everything seemed to be honky-dory. I just feel that at this point, when the world is circling its wagons against offshore jurisdictions or offshore centers, and Cayman in particular, I think it behooves us all who understand industry and what goes on to show some support and acknowledge the work that SEMA and other regulatory bodies in the Cayman Islands do that have been the foundation of providing a robust regulatory platform whereby persons and businesses that wish to participate and take advantage of the products and services regulated in the Cayman Islands, the ultimate backstop for that is the Cayman Islands Monetary Authority and its management team, who are made up of some really super qualified, hardworking people. I'd go as far as to say, when you go down the food chain into the actual divisions, when you look at the number of people that industry have poached from SEMA because of their abilities, because of their knowledge, because of their work ethic in part, that is a testament to how well I think the organization is run. Now, does it have challenges? Yes. But does every organization? Most definitely. Given the resources or lack thereof, and the fact that we managed to maintain a very positive and robust regulatory regime, which the mass international media do not want to acknowledge or recognize, and in my opinion, the Cayman Islands could do a better job of highlighting. You might not like him, but there's the Tony Traverses of this world. There are certain things that him and Tim Ridley say. Their personalities might grate on certain people, but when it comes to the protection and the defense of the Cayman Islands financial services industry, they are world-renowned players who bring a lot of credibility and offer, again, a very serious, robust, and thorough defense of the Cayman Islands. I just think it's important that people understand the Paradise Papers are coming off the back of the Panama Papers, and it's due to leaks coming out of the Bermudan law firm there. I would dare say SEMA can't be held responsible if there are weaknesses in cybersecurity, or if some employee decides that they're just going to download files and share it with the world. Where I find it incredible that SEMA are held accountable to a different standard. Remember the entire FIFA fiasco when Jeff Webb was arrested in Switzerland, and so on and so forth. We had our local press attacking and vilifying the head of SEMA, the head of a very important supervisory division, yet there were 3 to 4 senior partners of a major law firm that Mrs. Lewis used to work for in attendance at the time when all of this went down, and to date, their names have never been called. They have never, their names have never shown up in print, and we conveniently pretend as if we didn't have law firms facilitating, structuring, and profiteering from some of the said nefarious activity that is being alleged against the major players in FIFA. So I just wanted to call in and say, I try to be objective. I offer my criticisms and solutions to successive governments when I think they do some really stupid things that are going to cost us money. But I think at this moment in time, when we are under the gun, we have to support every regulatory agency in the Cayman Islands and all of the people that are working hard to make sure that we maintain a positive reputation, because right now it is the Cayman Islands against the world. So the government could be doing more to help SEMA. Industry, SEMA, and the ministry need to work in conjunction so that there's a unified sort of message that goes out to the international press, so that the misrepresentation of what is happening can come to a halt, or at least we can slow it down. But everybody needs to be on Team Cayman right now, because as I said, there is no other way to put this. It is Cayman against the world right now. So just wanted to offer that up and suggest that you have ministry officials, the head of SEMA, our management team, come in and just explain to the people what is going on. Mm-hmm. The emailer was absolutely correct. SEMA do not have any sort of regulatory oversight of law firms and accounting firms, but at the end of the day, there are processes in place. If you hear industry saying that SEMA or any regulator is perhaps has too much of a heavy hand, that just goes to show that they're doing their job.
Yes.
If they weren't doing their job, we wouldn't poach some of their people from SEMA also, because it's a great place where people have trained and developed their skill sets that, industry is now making a bag of money off of. The proof is in the pudding. If every lawyer were to own up to the fact that they can call into SEMA for free, get advice, guidance, or be shown the relevant section of any form of regulation or legislation, these lawyers then turn around and bill between $400 and $800 an hour without ever acknowledging that SEMA helped them put those briefs together. Again, the proof is in the pudding, and I just wanted to say that from one Caymanian in the financial services industry to the people that help make sure that when I go anywhere, I can say that we are a well-run, well-regulated jurisdiction.
Thank you very much, Scholar, for that resounding endorsement of SEMA, and I want to thank all of those, including Ms. Teresa, who have really clarified the situation with them as well. We're going to shift gears now because we know Dr. Macfield wants to talk about a different subject, and I'm going to preface that discussion by reading from one of the UK newspapers. Burkhoff, that's the Speaker of the UK Parliament, may consider contempt of Parliament if Brexit impact paper is not published. John Burkhoff has said he could consider contempt of Parliament claims if the government fails to release Brexit impact assessments. MPs approved unopposed Labour's motion, which asked for a quote-unquote humble address requesting the Queen to direct Brexit Secretary David Davies to release the documents. There was confusion during the debate about whether a vote triggered by Labour's use of an arcane parliamentary procedure would be binding. That arcane parliamentary procedure is something called a humble address. It says, since binding motion on handling Brexit report to select committee has passed, Speaker makes it clear government must comply or be in contempt. And it goes on to talk about the various areas, of contempt and how it is handled in the UK. And of course, part of that is reliance on Erskine May.
Yeah, so examples, for example, of contempt is giving false evidence to a parliamentary committee, or threatening an MP, forging documents, bribing members. But it also speaks to each member of parliament actually doing something as an individual that can actually bring it into disrepute as well.
Yes.
But the question that we are faced with is that, and that remains is to be answered here in the Cayman Islands, is the scope and the content of the Legislative Assembly contempt powers, whether they have those powers at all. They surely have them in the UK Parliament. They have them in the Canadian Parliament and the New Zealand and Australian Parliament. But I see nothing in the standing orders here or in the Immunities and Privileges Law 2015 or 16 was this, or 2006, that gives the Speaker power to hold a member in contempt, especially outside of actions outside the House. Specifically, I say, and against whom and what conduct does the Legislative Assembly see as contempt? Now, in the British parliamentary system, contempt has been defined as any act or omission which obstructs or impedes Parliament in the performance of its functions, which obstructs or impedes a member or officer of Parliament in the discharge of his or her duties, or affronts the dignity of Parliament, or which tends either directly or indirectly to to produce that results. So while that is helpful in relation to the British, the UK Parliament and other Parliament, it does not help us here, because we have no legislation here that defines contempt, and we have no legislation here that says that the Speaker can hold a person in contempt of Parliament. Most of the contempt cases, the definition of contempt cases comes out of the case law, the constitutional case law. So, and then we have to contrast that with the freedom of speech, that the MLAs have in the Legislative Assembly. That their immunity and privilege law protects them in their debate and so forth, and so it confers privilege on them from immunity from proceedings, protections, and so forth. But what happens if it's made outside the House? Can that be treated as a breach of privilege, and requires a member to be in contempt? I don't know. I haven't seen anything in the Legislative Assembly here that will allow us to do that. Mm-hmm. Now, on another hand, I think I've just wrote it down here.
Okay, I'm going to give you an opportunity to find out. We have to take a commercial break so that you can find out at the same time. Yeah. Folks, please stay tuned for the record. We'll be back shortly. Good morning and welcome back to For the Record. In the studio with me, Dr. Steve Macfield, Mr. Risa Pitcairn. We had to interrupt Dr. Macfield to go to a commercial break, so we're going to pass the mic back over to him now.
Yes, as I was saying before, as Mr. Kitchener-Solomon had said, yes, as I was saying before I was interrupted. Yes, it says, as I was saying before, the Legislative Assembly signing Orders 2006 revision does not have any powers in it that gives the Speaker the right to hold anyone in contempt. Neither does the Immunities and Privileges Law 2015 revision has any powers in it. The only power that comes nearest to what the Speaker may be able to do is in Section 25 of the Immunities and Privileges Law 2015. And Section 25 says, the powers of the Speaker under this law shall be supplementary to any powers conferred on the Speaker by the Constitution of the Cayman Islands. And when you go to the Constitution of the Cayman Islands, the Constitution of the Cayman Islands is silent about the powers of the Speaker, especially in relation to contempt. Now, if the Speaker goes to Erskine Mays, which of course, is the Bible for the parliamentary procedure in the United Kingdom Parliament, if the Speaker goes to that and can somehow find some powers of contempt that he can transfer from their system over to from their parliamentary system over to our system, and remember that their parliament is supreme. The UK Parliament enjoys supremacy within the English constitutional system. This is not the case in the Cayman Islands. So, the Speaker, if he has powers or if he finds powers to hold anyone in contempt, he would then have to have a privilege committee. He would have to bring a privilege committee in place, and then he would then make a report to that committee to say that that a contempt matter, a contempt has happened, and the dignity of the House has been breached, and the committee then would have to have a hearing. And if Mr. Miller was the subject, or any other MLA was the subject of that, he would be able to appear before the committee with his counsel and challenge the authority of the committee. And then the committee would have to make a report to the whole House, and then it would have to go to the whole House, and the whole House would have to vote whether or not it was a contempt or not a contempt before the Speaker would be able to do anything about it. So that's the position in the Cayman Islands. So surely in other jurisdictions there is contempt proceedings because they have specific provisions in it to deal with contempt. We have no such provisions to deal with contempt in the standing orders and in the immunities and privileges law or in the Constitution.
So in that case, then they would refer like they usually do to Erskine May? Okay.
So, but I'm just asking whether or not then the Speaker obtained legal advice before taking those steps. And if he did take legal advice, this brings us back to the question I asked, I think last week.
He did say he would consider. Or are you talking about the rules?
That's right, because the mere fact that he's going to consider it, I am assuming that to even think of considering it, he would have obtained legal advice. So what I was saying, and I referred to last week, how do you get, for the balance, to get his view on record as well by way of discussion? Because I know the view that we took was that, he may not feel comfortable or the office may not feel comfortable with having that kind of engagement.
Mm-hmm. But the Speaker himself cannot deal with matters of contempt summarily. It has to go through a procedure. And as I say again, the use of contempt of the Legislative Assembly to punish public speech cannot be reconciled with the existing requirements of the Constitution of the freedom of speech. Also, that has to come into play. And the standing orders cannot extend the contempt powers of the Legislative Assembly to the Speaker or to anybody else in the Legislative Assembly because they're just not there.
Mm-hmm. Now, when we talk about naming here in the Cayman Islands in Parliament, we hear more about a member of the Legislative Assembly being named. Now, there are options, it seems, in the UK where MPs that are held in contempt can be asked to apologize, they can be suspended, or they can even be expelled by their fellows, right? Offenders can also theoretically be confined to a room in the Big Ben Clock Tower, although this power has not been used since the 1880s. So, again, we need to look and see exactly what remit the Speaker has in this particular case. But it appears as if what you're saying, Dr. Steve McFeel, is that he cannot be judge, jury, and executioner.
No, he cannot. And the problem is that in the UK, there are specific provisions that allow that to happen, allow people to be confined to the tower. If you look at the standing orders and the immunity and privileges law, the most the Speaker can do is name someone and put them out of the Legislative Assembly for a specific time. Other than that, he cannot do anything more than that, really. And we cannot hold him in contempt. And because to do that, he would have to bring a privilege committee, because you see, it would be a breach of the Legislative Assembly members' privilege. And so that would involve a privilege committee come into place. The Speaker then stating to the privilege committee or putting his case to the privilege committee what was the contempt, and they would have to rule on it, make a report to the whole House, and then the House would have to come back and vote whether or not it was a contempt or not. And then the Speaker would then the House would make a order recommendation of what would happen to the contemptor, and then that was when the Speaker then would be able to do something about it. But as it stands, there's nothing in our law that gives the Speaker the right to hold anyone in contempt, especially outside Parliament.
Okay. I am almost at a loss for words. That usually doesn't happen to me in this day and age. Now, well, I'll ask this question. Can a person who is not a parliamentarian be held in contempt as well? Let's say, for instance, those rules that the Speaker laid out, if they have been passed outside of the Legislative Assembly and other persons are now in possession of those. Now, they were read out in the Legislative Assembly, so they certainly became publicly known. Can a member of the public be held in contempt of as well?
Well,
of the
a member of the
Legislative
public,
Assembly?
I think
Within the precincts or outside the precincts?
there are rules in the standing orders and in the immunities and privileges law to deal with people outside of Parliament and strangers in Parliament.
Mm-hmm.
Those are definitely defined in the standing orders how the Speaker should deal with them. And certainly, the action can be brought against somebody outside the Legislative Assembly, for instance, for reporting falsely what happened in the Assembly, or reporting things that did not happen in the Assembly, or for taking papers out of the Assembly that should not have been taken away, so forth. But that has to be referred to the proper authorities to do, and under the standing orders and under the immunity and privileges law. That's a different matter. And then, but for instance, reporting matters that happen in the Assembly, as long as they're right, as long as their opinion of what happened in the Assembly, they are immune from prosecution in civil and criminal procedures.
Yeah. What I found extremely interesting and intriguing was the provisions of this humble address to Parliament that at least gives some leeway to the opposition that they can get something done rather than relying on the good graces of the government. Because here in the Cayman Islands, in our Legislative Assembly, when a private member's motion is brought, there is no legal obligation whatsoever for the government to put into effect what has been passed in the Legislative Assembly. They have to recognize it, but there's no legal obligation. There's no way for the opposition to go for them to enforce that motion that was passed by the Legislative Assembly. We have to take a break now. For the record, we'll be back shortly. Good morning and welcome back to For the Record. I want to remind you that we hope to have representatives from Department of Children and Family Services on at 9 o'clock. We had some scheduling mix-up this morning, but we'll get everything sorted out sooner or later. Back to Dr. McField.
The other point I would like to make is the question of whether or not Mr. Ezra Miller is the leader of the opposition, and whether or not he has the right to consider and place in the Legislative Assembly a shadow cabinet. I just want to read what the Constitution says about that. Section 68 of our Constitution says that there shall be a leader of the opposition who shall be appointed by the governor. And it says the governor shall appoint as the leader of the opposition the elected member of the Legislative Assembly, recommended by a majority of the elected members of the Assembly who are members of any opposition political party, whose numerical strength in the Assembly is greater than that of any other opposition political party. Mm-hmm. And it goes on, if it appears to the governor that there is no such party, but there is an elected member of the Assembly who would be acceptable as leader of the opposition to a majority of the members of the Assembly in opposition to the government, that member, or if it appears to the governor that there is no such person, then the governor shall appoint as leader of the opposition that person who is, in his or her opinion, would be acceptable to the greatest number of members of the Assembly in opposition of the government. Let me stop there right there. Mr. Miller was elected by the greatest number of the people in the opposition in the Legislative Assembly. And therefore, under the Section 68 of the Constitution, he was duly appointed as the opposition leader. Now, I understand that the Speaker is saying that he has no such right because he's not a member of the political party. But here's what the Constitution says. In this section, opposition political party includes a group of members of the Legislative Assembly in opposition to the government who are prepared to support one of their members as their leader. So clearly, the Speaker has no right to question whether or not Mr. Miller is the opposition leader and whether or not he has the right to appoint a shadow cabinet. As the opposition leader, he has that right, and he has that right under the Constitution, and that right is clearly imposed by Section 68 of the Constitution, and the governor did what she had to do when the majority of the members in the opposition say that Mr. Miller was their leader, and therefore he's the leader of opposition, and he can appoint any shadow cabinet or shadow ministers that he feels are justified to do so.
Now, the assertion made by the Speaker when he read out the persons who were elected to the Legislative Assembly and their party or their non-party affiliation, he pointed out that they were all independent. So as a result of that, he didn't see them being able to be a shadow.
Completely wrong.
Government. Okay,
that is completely wrong, because let me say it again. Section 68(7) says, in this section, opposition political party includes a group of members of the Legislative Assembly in opposition to the government who are prepared to support one of their own members as their leader.
One of our members of the Legislative Assembly asked us to take a look at Standing Order 88 as well. I don't know, you have a copy of the Standing Orders with you?
No, I don't have a copy of the Standing Orders here.
Maybe that member of our Legislative Assembly may want to call in and
tell us what it says.
Tell us what
Section 88 says.
What Standing Order, yes, Section 88 in the Standing Order says as well. Now we're talking about our Constitution, and it is important for us to remember also that today, the 6th day of November, is the 8th anniversary of the coming into effect of our
That's right.
Cayman Islands Constitution.
That's right.
And we should give recognition to that as well. And I would like to read what the Constitutional Commissioner's message says. Says this year makes the 8th anniversary of the implementation of the Cayman Islands Constitution Order 2009. The Constitution, the documents, is the law that transcends all others in our islands, outlining the criteria with which all other local legislation should be aligned. The Constitution was laid before the UK Parliament on the 10th of June 2009 and came into force on the 6th of November 2009. Says the 6th of November is therefore a significant day and represents an occasion for all members of the public to reflect on the historic implementation of our current Constitution and to seek to learn more about the way in which the Constitution operates. And there's more that they talk about here. What we also need to consider is the those imperfections of our Constitution as well, and what needs to be done about those. Some clarity in the areas of, for instance, the qualifications to be an elected member of the Legislative Assembly, and the disqualification section. We need to have that clarified. We need to have clarified the whole issue of junior ministers and councillors and things like that.
Exactly.
So after 8 years, those are things that we really need to start to look at.
But also, OC, making sure that we have an appeals to the decision made by the Grand Court.
Yes, you know, as well. But and that's a combination of the Constitution and the elections law as well. We have one caller. Let's go to the phone lines. Caller, good morning. Welcome to For the Record.
Good morning, everybody in the studio. My name is Billy. I just wanted to comment a little bit on the very valuable points being made in the studio by yourselves in there.
Hi, Billy. Good morning. Nice to hear from you.
Well, it's good to hear from you every day.
Thank you.
Yes. Now, I think the points being made really are very valid. Having worked in government and in legislation for some time, some of the things that I found about the standing orders is that the standing orders do need a general look, and I think you've already made that point. In 2017, there were very good amendments made to the standing orders in response mainly to the change in the Constitution, as you have said. But I think what this is bringing out, this issue relating to contempt, is that perhaps there is a need to take a more general look at those standing orders and see how they respond to modern-day Cayman. For example, you talked about motions and how motions, there is no legal obligation for government to implement motions. And that is quite correct. And I think it needs to be dealt with in the standing orders and possibly also in general legislation as to what the policy should be regarding those. In some other countries, they have, for example, actual guidelines more detailed about how a private member can actually bring legislation and how that legislation, how legislative drafting department would participate in drafting that legislation if private resources are not available.
That's right.
Yes.
There are even allocations, like they say, in 1 week, government can't take more than, say, a certain number of hours to deal with private drafting and so on. So that needs to be well defined, partly in the standing orders, partly in the practice. There are also some small issues, such as one which was experienced some years ago. I remember a few years ago, there were 8 bills which were brought to the House to deal with a certain crime wave at the time. And those bills had to be introduced one at a time. They were all related, but they were introduced one at a time, and the debate tended to be the same with each one of them. Now, that all could have been avoided by a procedure whereby you introduce cognate bills. The person introducing the bills gets up and says, these 8 bills are related, they are more conveniently debated together, and if that is accepted, and then they are debated together. So that there's a whole range of constitutionally important things that need to be done to the standing orders, as well as some matters of detail which need to be addressed in the standing orders. And I think the answer to it is, at this time when this issue has arisen, it is a good time to see if all the standing orders can be reviewed together so that they can be modernized.
Thank you. Thank you,
Thank
caller.
you very much.
Thank you, caller.
Thank you very much, Billy.
And as I say again, standing orders cannot confer powers that it constitutionally does not possess.
Yeah.
And so, in final, I would like to say that the dignity of the Legislative Assembly is a duty that falls squarely on the Speaker and the MLAs themselves. The dignity of the Legislative Assembly falls according to the how the MLAs and the officers of the LA conduct themselves within the House and without it. It is what MLAs do, not what citizens say about MLAs, that determines whether the LA is perceived as a dignified body or not. And I also want to say that that it is time that we bring the standing orders. Although we had revised them lately, it's time that we bring the standing orders into the last revision of the standing order. The standing orders was in 2006. That was even before the Legislative Assembly, before the Constitution. So it's time that we bring them into force, update them and bring them into in line with the Constitution, so that we have a clear picture of what goes on, what obtains, as they say, and they should augment the Constitution, and bearing in mind all of the requirements of the Bill of Rights of freedom of speech, not in of the legislative of the members of the Legislative Assembly under the immunities and privileges law in the House, and the freedom of speech outside the House under the Constitution.
Thank you very much for that, Dr. McPhail. We're going to go to our headline news at 9 o'clock. Please stay tuned. For the Record, we'll be back immediately after headline news. Good morning and welcome back to For the Record. We have one caller on hold. Caller, good morning. Welcome to For the Record.
Good morning, O.C., Steve, and Dr. McPhail and Teresa.
Good morning, sir.
Yeah, I had to call in because it was me who texted you about that Section 8, number 88.
Yeah, I didn't name you, but
yeah, but I don't have a problem with that. in the public domain, and whatever I say is regurgitation or consumption, my friend. What Section 88 says, Standing Order 88 says, is matters not provided for by standing order.
Yes.
1. In any matter not herein provided for, resort shall be had to the usage and practice of the House of Commons of Parliament of Great Britain and Northern Ireland, which shall be followed as far as the same may be applicable to this House, and not inconsistent with these standing orders, nor with the practice of this House. So that's conventions coming in there, and things like, we got 2 hours to speak. If they only got 20 minutes up there, that's the kind of stuff they're talking about there that is not inconsistent, okay? 2, in cases of doubt, the standing orders of this House shall be interpreted in the light of the relevant usage and practice of the House of Commons, but not restrictions.
But no restrictions
Which the House of Commons has introduced by standing order after the making of these orders shall be deemed to extend to this House or its members until the House has by standing order provided for such restriction. Okay, that's our House.
Okay, can you put that in local
layman's,
parlance and layman's terms for us?
What's your
Well, what happened is,
what's your definition of that?
what happens is the House of Commons may put a restriction on their members, okay? So we cannot introduce that or use that until we have put it in law.
Yeah, exactly. That's what I said this morning too.
That's correct. So I call in to agree with a lot of what you say, but with regards, I would slightly disagree with him with regards of not having provisions of contempt, because this is what the speakers relying on. Going back to Erskine May, we're contempt. But we should also be cognizant of the fact that whilst contempt attracts penal action, it has been hundreds of years that has not been applied. The last one must have been in the 70s or 80s, where a law firm went after the members of Parliament, and the Privilege Committee ruled that they should apologize, whereas they could have had applied penal sanctions. It is not used that much anymore. For hundreds of years now, it hasn't been used. But we also have to appreciate that the standing orders makes provisions so anyone who tries or does something to disrupt members in the carrying out of their responsibilities in the Legislative Assembly. I had a situation during the last administration where I spoke of a particular situation on the floor of the Legislative Assembly, and the person's name that I called, and these are all facts, I didn't fabricate anything. That person wrote the speaker asking to expunge what I said in the Legislative Assembly. Then we had this speaker who, during the last administration, tried to lay a confidential letter, and this is public knowledge, between Rich and Conley and the Airports Authority. And the government tried to stop him. He was leader of the opposition at the time. And we convened and consulted with England, and you cannot stop a member of Parliament from laying anything that comes in his possession. You may ask him because of the confidentiality of it, but you cannot stop that member. I want to also quickly agree with Bill. These things on motions, from ever since I went there, and I had a reasonable appreciation and understanding of the legislature. The legislature enables the speaker, and it also enables the executive. So when I got there, the resolve on all motions says the government to consider. Now, when it comes to financial appropriation, then that's a different matter, because the legislature shouldn't enforce upon them to do it because we don't know whether we can afford it or not. But on matters relating to the changing of laws and the what have you, that is precisely why, Steve, the executive is only 2/5 of the legislature. The legislature has absolute authority over the executive and the speaker. The speaker is put there to manage the proceedings of the legislature and see that things are not repugnant or what have you and what have you. And that authority is passed to the speaker from the members, thus the enabling of the speaker to do what they do to manage the members of the Legislative Assembly. We need to change our standing order, and we need to do it fast. We made an attempt at it during the last administration. I was on the standing order committee to review it, and Mr. Miller was on the autonomous to make the Legislative Assembly autonomous, which I have spoken about all throughout the Commonwealth for the last 10 years, 15 years. Now, just Friday, we approved, which I did not even remember, we approved what Billy was just talking about, that we just made some amendments to it, which is true. But that was to bring it into conformity with the Constitution, such as, the sections of the Constitution that is referred to and what have you. But the meat of the matter and the operation of the legislature under our standing orders is outdated, it is old, and something needs to happen. For instance, one of the things that I've been proposing ever since we got there, and CG supported me, Ralston supported me, is we start the legislature at 2 o'clock in the day. That gives Cabinet the opportunity to work all morning and then come to the Legislative Assembly, because Cabinet manages the country. And those are the things I think that needs to be done.
Mr. McLean, while we have you, and if you still have available a copy of your standing orders, look at Standing Order 87. Says unless the presiding officer otherwise directs, not less than 12 days notice of a motion to amend the standing order shall be given, and the notice shall be accompanied by a draft of the proposed amendments. The motion shall be set down for the earliest sitting after the expiration of the notice. When the motion is reached, the mover shall move the motion, and after it has been seconded, and the question shall be put forth, that the motion be referred to the Standing Orders Committee. If that question is agreed upon, no further proceedings shall be taken on that motion until the committee has reported thereon. Now, this speaks to a motion. Now, is your interpretation of Standing Order 87, does that mean that you could bring a motion for the amendment of all of the standing orders, or only one part of it? Because it would seem to me as if you could use Section 87 to get the wheels in motion in terms of having the standing orders amended, rather than waiting for someone on the government side or the speaker or whatever to initiate it.
Yeah, let me give you 2 examples. When I went to Parliament in 2000, we had 4 hours of speaking time on every subject.
Mm-hmm. Too much time.
Ralston Anglin at the time brought a motion to change that standing order, which was referred to the committee. Okay? Mm-hmm. The next example was we all agreed that we needed to do a complete review during the last administration. The premier brought that motion without the details of it, but it was to refer it to that committee, which was at the time chaired by the deputy governor by virtue of his position there. Okay, because the governor got approved these too, so it falls under her. So that's where it's represented. We just changed that to put the speaker in charge of that now. However, if you look at 86, it says any of these standing orders may be suspended at any time for a specific purpose. So, and bringing that, the premier would have suspended 87 and just do a motion. You see what I'm saying? And just do a motion to allow it to be referred straight to the standing order committee for a standing committee for a complete review. And that's what happened during the last administration. We didn't get through with this one, but they drafted a law for the autonomy of Parliament, i.e. the separation from the executive, which I've been harking on all my life. Because right now, the executive controls the budget, it controls the staff, it controls everything of the legislature. There aren't many places in the Commonwealth that we experience that. We all saw the validity of separating it, and I have been asked to do that on a number of occasions at conferences, which I did, Trinidad, Namibia, all over the place. So yes, we could move a motion now, but we would have to just list everyone in there and say it needs to be changed with some little narrative to do it. But by the government bringing it, it was okay because we had all agreed already. So they didn't have to list that. It just referred to the committee. Now, Mr.
So when 86 refers to suspension, you suspend but it still remains in
standing
place.
order in place, yes.
Yeah. For instance, the standing orders, the presiding officer may grant general permission. I'm just reading one. Permission to the resident and journal newspaper to attend the house. We could suspend that, but it still
remains in place.
But it's only for that specific purpose that day.
Okay.
Before
we let you go, because we have to go to commercial break, Dr. Steve McField had a question in relation to you said what happened to. You were asking him just now what happened to
your motions for the independence of Parliament, of the legislature from the executive.
That's precise. So now it is in law, but it has not been enacted.
Why has not been enacted?
Well, it has not been brought back to the Legislative Assembly for debate.
You mean it's a bill?
It's a bill.
Okay.
It's a bill.
Okay, got you.
It's a bill. It was proposed. It was a bill that was written, but it hadn't been brought back. And the thing is, what happened to it?
Very quickly, because we got to go.
All right. People are not willing allies of change, eh? And then people get a little concerned. And so I think that's the hold up on it. But I would like to see it come back. If we need to tweak that bill, then we need to do that.
Okay. Thank you very much, Mr. McLean, for that. Folks, please stay tuned. For the record, we'll be back immediately after this commercial break. Back to For the Record. We're doing a little bit of shuffling in the studio, but we finally have some guests this morning as well with us. It's our pleasure to have in the studio with us this morning Miss Melissa Alexander, who is a social worker in the Department of Children and Family Services. And also with us, Ms. Keisha Smith, also a social worker with the Department of Children and Family Services. And we're going to be discussing a very important event that will take place soon here in the Cayman Islands. So, ladies, good morning.
Good
Welcome to
morning.
For the
Good
Record.
morning.
Thank you for having us.
Thank you for having us.
Thanks for being here. Tell us, Ms. Alexander, well, first of all, explain the work that you do, introduce yourself, and tell us some things about this expo.
Okay, so as mentioned, Melissa Alexander. I am a social worker with the Department of Children and Family Services. I am specifically stationed at the MASH, the Multi-Agency Safeguarding Hub, on the intake team. So I am part of the team that deals with the referrals that come in the first point of contact with the department. And about the program that we have planned, it's an expo that we are putting together in conjunction with other agencies on island that are a part of safeguarding the children of the Cayman Islands. And it is going to be taking place November 15th through the 17th, from 9 a.m. to 3 p.m. and 5 p.m. to 6 p.m. And it's going to be held at the old library in Georgetown.
Okay. Can you repeat those that date and time for the benefit of our audience?
It is Wednesday, the 15th November to Friday, the 17th November, from 9 a.m. to 3 p.m. and 5 p.m. to 6 p.m. at the old library in Georgetown.
Okay, and who can attend?
It is open to everyone. We are encouraging parents to attend. We are inviting the schools to attend as well, so that the children have the opportunity to put a face to the agencies that are working to safeguard them.
Okay, Ms. Smith, good
Yes,
morning.
sir. Morning.
Tell us about your role.
My role is similar to Ms. Alexander. I am also stationed at the MASH, the Multi-Agency Safeguarding Hub, where we work collectively with the police, the Family Support Unit, frontline worker. So any matters that come into the department, we respond. We're the first responders to those matters.
Okay, is child abuse is something being celebrated in recognition of what is happening, with young children this month as well?
Yes.
Tell us about that.
Every year, November 19th, it is the World Day for the Prevention of Child Abuse. So this year, we are observing that day, and we are taking the opportunity to shed more light on the topic, as well as just general protection of our children. And that includes bringing in, as I mentioned, some of the agencies that safeguard our children. So we're talking about the Health Service Authority, Fire Service, Police, Family Resource Center, just to name a few.
And can you tell us a little bit more about child abuse, the various forms that it manifests itself?
Well, child abuse can manifest itself in a number of ways. We know of the physical abuse, the emotional, sexual abuse, neglect. Those are the ones that we generally see more of.
Okay. And in the Cayman Islands, what is the prevalence, of it? How much of it do we see? Can institutions, governmental institutions, for instance, be complacent when it comes to child abuse? I use one example, and this may be a subtle case, and I'll ask both of my co-hosts to interject in this. We keep hearing about the condition of some schools in the Cayman Islands and what the children have to endure in the environment of those schools. Would that be something that would be considered a subtle type of child abuse? We won't let the civil servants answer this one. I'll refer to my two co-hosts in that regard.
Well, firstly, I don't know much about the profession of social work. I did work for a social worker one time in my life, but that was his profession. He became a legislator and a Speaker of the House of Parliament in Canada. But it seems to me that that social work should be more concerned with the conditions of people in their private homes, in their private institutions. I just wonder how you were able to conduct your profession when you are sharing office with the police department, because that would be the last resort for a social worker to actually have the police involved. It seems to me that it's only when someone has committed an offense against a child or domestic violence that you would then call the police. But how is it? How are you able to carry out your work in an impartial way when you were sharing office with the police department? I don't understand that at all.
Well, it is a pleasure also to have in the studio with us the Director of Children and Family Services. I want to say good morning to her. Welcome back to For the Record. She's been here before, no stranger. I'd like you to introduce yourself to my co-hosts as well as our listening and viewing audience.
Good morning, and thank you again for having us. I'm Felicia Robinson, Director of Children and Family Services. And I think I came in at a good point.
Yes, go right ahead.
To comment on this. Okay. Social workers have always worked with several agencies to protect children, and police have always been one of our partners. The idea of sharing this space has to do with the fact that very often we get reports, and not all of them, as you correctly say, may require police intervention or support to go out to investigate a matter. We look at child abuse matters following two parallel streams. We have an interest, one, in supporting any investigation in the event that there is an allegation or suspicion that some criminal harm has been done to a child, and therefore we provide the support to the police in terms of those investigations. Alongside that, which is why I said there's a parallel process, our responsibility is always to safeguard that child and to provide whatever support is needed to the parents or the family members to keep that child safe. So yes, it is not in any way a conflict. We share that space with the police to be able to facilitate rapid assessments of the harm, to be able to facilitate the joint working together. There are times when, because of the nature of the report that we might get, sometimes it's domestic violence or whatever, it may be some other level of trauma, the police will require the social worker to be present to help them to support whatever they're doing. Sometimes it is not because there's a criminal matter. There may be an incident involving police, there are children who are present, or social workers immediately can respond with them to take care of the needs of the children, to be able to address the trauma, to ensure that that child is safe in the middle of all of what is going on. So there are really two streams that we work. But ultimately, police have a joint responsibility with our social workers to ensure that our children are kept safe.
Okay, we've been given permission to go on for an additional 10 minutes since there was a mix-up with the time that you were supposed to be here. Ms. Susan, do we take a commercial break at 8:30? We go straight on. So, Ms. Robinson, this real segment is really for you, and we want to ensure that your agenda is covered on here. So I'd like to again hand the mic over to you and to allow you to interact with your staff and tell our listening and our viewing audience more about what is taking place and the situation here in the Cayman Islands.
We appreciate it. This month we are particularly busy. We are doing several things. So tomorrow, November the 7th, we're going to be hosting a child justice seminar, where we are going to be exposing again all of our multi-agency partners to some information in terms of what do we mean when we talk about child rights, how do we prepare children for court proceedings, but also we want to introduce a look in a wider framework as to what value does forensic investigation bring to helping us to find justice for children. Very often we hear conversations around the fact, whether how evidence was collected or not collected, how this impacted upon outcomes and so on for children. And generally the public may not be aware that forensic is not just an area peculiar to police work. We have forensic social workers who are trained to support forensic investigations. We have forensic psychologists. So we are trying to bring that conversation in that forum so everybody understands how all of the team players come together to help produce better justice for children. So we do that on the 7th. And then the next week, again, we continue our activities within the public interface where we're going to be looking at hosting an expo. Again, not just DCFS, but with all of our partners. There's a particular message that we want to get out there. We want our public, our community members, our professionals to understand and to be involved in sending a message that we are in the business not of intervening after a crime or harm has been done to children. Our primary business is prevention, keeping our children safe, preventing those things from happening. And that's the message that we want to put out there through this expo, that there are several agencies, organizations, service clubs who have a particular interest in ensuring that children are kept safe. So we're bringing them together in a public forum to say to everyone, look, if you're struggling, if you don't know where help is available, these are all of our partners there, and we want you to come in and have a conversation with us.
Can you talk about specific legislation that we have in place now that is aimed at protecting children, protecting the rights of children as well? We know that we have something enshrined in our Constitution in relation to that, and we'll have one of my co-hosts talk about that in a minute. But Ms. Robinson, can you tell us more about legislation? You know, how we speak about the most vulnerable in our society, and we know that children are, as well as older folks in our community, the most vulnerable ones in our communities.
Okay. Well, we have the Children Law 2012, and that provides the framework under which we talk about protecting our children. But we also have other bits of legislation that speak to how we protect children's rights. So, for example, our education legislation speaks to how you protect the child's rights in terms of to having access to education and so on. So that we work it together. But I would say that our primary piece of legislation that looks to the protection of children and speaks to the overall welfare of our children is the Children's Law.
Now, actually, it's our Constitution.
As well as,
because Section 17 actually deals with that.
Yeah. He had mentioned the Constitution as the overarching framework.
You want to read Section 17?
No, so I was just going to pick up on some of the issues that you probably deal with and probably know about, where, for example, the right to basic nutrition, shelter, basic healthcare services, social services, to be protected from malnutrition, neglect, abuse, or degradation. You pointed to the abuse bit just now as well. Protected from exploitative labor practices and not to be required or permitted to perform work or provide services that are inappropriate for a child at that age, placed at risk, not to be detained except as a measure of last resort. And this was what I had in mind as I was listening to you, to have a legal practitioner assigned to the child by the government and at the public expense in civil proceedings affecting the child if substantial injustice would result. And I wanted to find out how prevalent is that, where you always have access to proper legal support.
When we have matters which we need to take into the court and we have to represent our children, we normally get representation through the AG's chambers. So there's a counsel who's assigned to support DCFS in taking matters forward.
Well, I'm usually in court as a lawyer, and so many times I've seen children come to court and the parents have to come to get obtain my services to be represented. The law, Section 17, say that it is the government's business to have a legal practitioner whenever a child goes to court. And then the other thing I would like to ask you is this: the protection of children clause in the Constitution talks about children having basic nutrition, shelter, basic health care services, and social services. How do you go about seeing that a child has basic nutrition and shelter and basic health, and And who do you go to when you have discovered that he doesn't have basic nutrition, shelter, and basic health? Who do you go to make sure that those things are provided to the child?
Okay, all right, fine.
Because, for example, I know children that go to school without lunch money.
Yes, without breakfast.
And I know when I campaigned before, I went and visited households where it was clear that the children weren't being properly taken care of. And I guess now that I have you here, now is a great opportunity to ask those questions.
Okay.
Yeah.
So matters such as children going to school without adequate nutrition, not having proper medical care, and so on, those would be what we consider to be matters of child neglect. Okay, and therefore it does come under our concern. If we are aware that children or families lack the resources to be able to provide care for children, then we will investigate it. We will also try to connect them into services. In terms of being able to provide nutritional needs and food, it may be that in the interim we connect them into a food pantry or food bank. There may be circumstances where we ourselves may need to ensure that we provide them with some financial assistance based upon the gravity of it. But it is really the needs assessment unit who these families are referred to, and they will assess them and make recommendation in terms of the services that they will get with respect to being able to take care of their financial food needs and so on.
So you guys work hand in glove with the
them.
needs
Yes.
assessment unit.
Yes.
But is it the public that brings it to your attention as to whether or not the children...
Or you bring it to their attention?
Any member of our community can refer a matter to our attention. School officials, church officials, anybody walking past and see a concern that they've got and they know this child. There is no limit. Anyone can bring a matter to our attention.
Right.
So if these services are not provided, then under the protection of children's clause in the Constitution, if those basic services are not provided, even though you refer them to the different agencies, what do you do now to make sure that they do?
If we have concerns that a family is not able to provide for the needs of the child, or we have concerns that we've made a referral and the services are not provided, we've got to follow up. And that follow-up could take various forms. We've got to follow up and do the advocacy. I did say that there are times when, even though the service should be provided somewhere else, DCFS ultimately may have to step in and say, you know what, we can't manage all of the drama around this. This is a vulnerable child and we will have to do what we need to do. And there are times when, yes, I have to make that decision. But we look to the agencies with the responsibility, with the resources, the mandate to do that, to meet that need. But we also rely on partnerships with our private sector, or community organizations, or clubs, and so on, to help us fill some of those gaps. So there's an ongoing conversation always about how do we get to plug the various holes that sometimes exist.
We're fortunate here in the Cayman Islands that we don't see what happens in other jurisdictions where you end up with fatal situations for young children in terms of the abuse that they receive. But we do see what I would consider a high prevalence of sexual abuse of children here in the Cayman Islands. And I know that we've discussed this on previous occasions as well, in terms of the culture, sometimes the infiltration of other cultures, where it is not unusual to a child in their early teens to be in other jurisdictions what is considered almost consensual relationships, but here in the Cayman Islands, we don't allow that as well. From a resource standpoint, how well is your organization posed to deal with the issues that you're confronted with? And we do know that the minister has said that they're going to give some of these things priority as well.
And I'm going to dovetail OC's question with one that is hugely sensitive, but I'm going to give it in the best interest of the kids, where I know that kids are oftentimes placed in the very invidious position of having to service men that are fairly old. And no, I'm a straight shooter here because, and on this issue especially, because it's children, and I want to ensure that I'm going to hold you guys accountable where that sort of thing is concerned. I know it's very sensitive. I know people don't like to talk about it, but it's important. So if I hear of these issues and stuff like that, I am sure and I'm hoping that you guys hear of them too, so that you're taking active steps to dissuade this type of behavior. And I understand oftentimes it's because, you know, folks want to satisfy some drug habits, or they want to satisfy certain economic needs that they may have. And this, I understand, is something that our children, especially our little girls, have to address.
Go right ahead, Ms.
Okay.
Robinson.
I'm going to take your concern first, where you talk about girls servicing older men. And so you would have seen my reaction when you clarify that. Yeah. I don't like the idea of servicing, to be honest, because children should not be exploited or be invited into under some definition of relationship with adult
I don't
men,
like these
because
things either.
it is not a relationship. They're being exploited. And as a department, no, we do not in any way support, whether it is culturally, whether it's habitually or whatever, any such conduct which exposes children to risk. Adults should have relationships with adults, not children. And any conversation that suggests that children can consent, it is not a real conversation. Children cannot consent, and neither does the law define them having the ability to consent to these so-called relationships. They're not relationships. So once we are aware of it or it is brought to our attention, yes, it will go through the similar process where it is investigated, and we look at that jointly as well with the police, because then we are crossing the law as well.
No, I'm going to stick to this because
we're running out of time.
Right,
so,
but I just want to ensure that proper steps are also taken to educate the public consistently, so that we actually own that kind of behavior when we see it, and we do something about it rather than sweeping it under the carpet.
Okay. Ms. Robinson, we're out of the time that the extra time that we've given it, but I want to give you an opportunity to make some closing comments, and in particular to the events that are taking place, so that we highlight that those persons who like to talk about our young people or children being the future and being vulnerable. Those are the people that we want to come out and join you at this event. So let's repeat what's happening, when, where.
So beginning next week, Wednesday, we are opening an expo. It is going to be open to all public. We want to see our children or adults, our community activists. We want to see anybody who has a passion or interest for protecting our children now. We cannot build a future if we do not protect them now. So please come out to the expo. We will be there to share with you all kinds of information as to what is available. We will be there also to take on board your concerns about what is going to happen for our children, what our programs look like, so you can be educated, but you can also walk away hopefully with some skills as to how better to work with your children and those that you come into contact with.
Okay, Ms. Robinson, Ms. Smith, and Ms. Alexander, I want to thank you for being here, passing this information on. And if there's anything that we can do to continue to promote this event on For the Record, please feel free to leave us with any documentation, and we can remind people of what's happening, when and where. Folks, I want to thank you for allowing Radio Cayman, and by extension For the Record, into your homes, into your vehicles, as you traverse the busy roads of the Cayman Islands, into your places of work, whether it be an office cubicle or if you're working in the outdoors. I also want to remind you that we are our brothers and our sisters' keepers. There is always someone out there who's less fortunate than we are, and I ask you to extend a helping hand to them. If you can't do that, then I suggest you donate to a worthy charity, because we always want to consider those who need, not necessarily those who want or those who crave. I say to you, have a great day. Continue to support your radio station, Radio Cayman. Join Sterling Dwayne Ebanks at 12 noon for a talk today. And before I ask the good Lord to bless these three beautiful, wonderful full Cayman Islands, someone in our listening audience wants to be repeated against when, where, and times.
We start Wednesday, 15th of November. We continue until Friday, 17th. We're open from 9 a.m. to 3 p.m. And then 5
And
to
the
6
location?
p.m. Location, the Old Library in Georgetown.
The library in Georgetown.
Old Library.
Okay, the old library in Georgetown. Okay, thank you very much. Have a great day. And as usual, we ask the good Lord to bless these 3 beautiful, wonderful Cayman Islands.